When it comes to states' rights to prosecute crimes, the Constitution gives, but it also takes away. What's happening in Minnesota right now is a textbook example of that tension. What's happening in Minnesota raises a basic constitutional question. Who gets to investigate when a federal officer kills someone inside a state? The federal Constitution gives states real authority here. If a killing occurs in Minnesota, Minnesota has jurisdiction over Minnesota crimes, even if the person involved was a federal officer. The federal government cannot prohibit a state from investigating or prosecuting violations of state criminal law. The U.S. Supreme Court has been clear on this point. In Gamble v. United States, decided in 2019, the court reaffirmed the dual sovereignty doctrine. Because the state and federal governments are separate sovereigns, at least in theory, each may prosecute the same conduct under its own criminal laws without violating the Double Jeopardy Clause. A federal investigation or prosecution does not, by itself, bar a state one. That same federalism principle cuts in the other direction as well. Just as a state cannot be prevented from enforcing its own criminal laws, states are not required to assist the federal government in enforcing federal law. That principle, often referred to as the anti-commandeering principle, is the constitutional backbone of so-called sanctuary states. States may choose not to assist federal immigration enforcement, and the federal government cannot compel them to do so. But federalism cuts both ways. Where the U.S. Constitution gives states some rights, it also takes some away. While a state has the authority to investigate and prosecute, the federal government does not have to assist the state in doing so. Cooperation is common, but it's not legally required. According to the Minnesota Bureau of Criminal Apprehension, the state initially began a joint investigation into the current shooting with the FBI, but the U.S. Attorney's Office later reversed course and placed the investigation exclusively under federal control. In so doing, they cut off the state from evidence and investigative materials. Minnesota then withdrew, stating it could not meet its own investigative standards without access to that evidence. That decision creates a serious practical problem when it comes to physical evidence. If key evidence such as firearms, shell casings, body camera footage, or forensic testing remains solely in federal custody, Minnesota may never gain access to it. Without that evidence, the Minnesota investigation can and probably will effectively stall. States can request access to federal evidence through what are known as TUI requests, which ask the federal government to produce evidence or allow testimony by federal government employees. But it's important to be precise. A TUI request is just that. It's a request. The federal government is not required to grant it under the law. Because of the Supremacy Clause in the federal Constitution, state subpoenas are not compulsory on the federal executive branch. A state government cannot force federal agents or agencies to turn over evidence, even in a state-level homicide investigation. The federal government can lawfully decline. Historically, these tensions were managed through investigative task forces and good faith cooperation, which help preserve transparency, accountability, and public confidence in both the state and federal criminal justice systems. What's different here is the apparent breakdown of that cooperation and the bad faith of the federal government under Donald Trump. Regardless of where you come down on immigration enforcement, that breakdown matters when lethal force is involved.